Any changes to the agenda? Okay. Tonight's public hearing will address case ORA 23-0002, Family Division Exemption. The normal public hearing process is that Planning Manager Ben Tarbutton will provide an overview of the proposed changes and answer questions that the Planning Commissioners may have. He will introduce the applicant's representative to provide further information. Next, the hearing will be open for public comments, and once all comments have been heard, the Commissioners will move to deliberations. Does any Commissioner feel that they have a conflict of interest?
I'd say I have a potential conflict because I have 4 kids, four needy kids, and I have one. So it could benefit me, I suppose, if this gets to go on.
Okay.
Or my kids, actually, benefit them. But I'm not sure if the conflict is with my kids or here. But
I think you're okay.
I think you're okay. Ben, will you start the presentation?
Sure.
Good evening, Commissioners. Ben Tarbutton, Planning Manager. Tonight, as you mentioned, we are going to be hearing ORA 23-0002. It is a family division exemption request. It may sound a little bit familiar to you, as this is a request that staff had brought up a couple years back. Some of you are new to this topic, though. Just as a brief little bit of history, at that application and staff's presentation, there was not the support from the Planning Commission and the Board of County Commissioners at that time, so eventually that request was withdrawn. However, as the code does allow, any member of the public does have the ability to submit a request for a text amendment, and that is what we have here tonight. We do have a member of the public who has submitted an application for the amendment to the family division, or to the divisions of land, the exempt divisions of land, specifically to add this family division exemption. The applicant has provided a complete application. The narrative does meet the application requirements based in the code, and is of course subject to your review. During the process, we did publish the notice for the request and the public hearing. However, we have not heard any written comments or received any written comments in the record. I think that's as far as all the introduction goes for staff. At this time, you know, being that it is an application of the public, if Rand Wickman, the applicant, would like to come up and introduce the rest of the case, then that's all staff had to offer at the moment.
Okay, got it. Is that better? Okay, great. As I said, I'm Rand Wickman. My address is 2992 East Gotham Bay Road, Harrison, Idaho. I am here tonight representing Vince Hughes behind me. He is a Post Falls property owner on this proposed code amendment. As Ben had indicated, this amendment was sponsored by my client due to the lack of movement on the issue from the county. It's been kicked around a little bit for a couple of years, was withdrawn previously. We think it's a good idea, and we think it's an idea whose time has come. And so Vince is sponsoring this amendment in hopes that we can get it over the finish line this time. Kootenai County has become pretty focused on playing defense against the development community and the impacts that they cause, and that's understandably so. You know, we're all seeing the impact of the growth that we're experiencing. But so much so that it appears that we may have lost sight of the impact of the ever-increasing county and agency restrictions on regular non-development folks that just want to take care of their own. This amendment, I believe, is a small step to help reestablish some balance here. The Planning Commission is certainly familiar with the content of this amendment, as you've discussed this specific proposal in at least 2 recent workshops and on several other occasions prior to April when I turned this application in. Put simply, this amendment would allow for a one-time gift of property to a family member, subject to numerous limitations, so that the process cannot be used by the development community as a way around the rules that are specifically targeted at them. It is similar to what is allowed in both Spokane and Bonner counties. This amendment borrows the best elements of each of their requirements. To qualify for a family division exemption, the property can't have been previously divided by an exempt family division. The owner has to have owned the property for at least 3 years prior to the proposed family division. An individual may only receive 1 parcel created by exempt family division in their lifetime. Parcels must be 5 acres minimum, have access to a public road, and meet all the code requirements. And lastly, parcels so created that are not retained by the original grantee are not eligible for building permits for a period of 5 years. I receive phone calls from a meaningful number of property owners that have no development experience whatsoever. Many haven't even gone through the home building process, much less developed a subdivision before. They want to give their young adult son or daughter an opportunity to stay in the community. They have a little bit of land, maybe 10, 20, 30 acres, but not enough to qualify for a 20-acre exempt division. They ask about how they can create a parcel for their son or daughter to give them a start on their adult life by providing an affordable place to build their first home. Right now, under the current rules, their best and often only option is to do a minor subdivision. Usually, the next question is, well, what will that cost? In the really unlikely event that they are ideally situated, minor subdivision is likely to cost a minimum of $20,000 to $25,000 to complete a basic 2-lot subdivision. It's more likely to cost $30,000 to $50,000 given most of the circumstances we commonly encounter in Kootenai County. And in situations where you have road improvements to do, build a common driveway or something like that, it can be well over $100,000. That puts that process out of reach for many of these situations. These kinds of costs can be accommodated by a developer. They simply run the numbers, and if the value is there, such that costs can be recovered profitably, they proceed. If it doesn't pencil out, they move on to the next opportunity. But if this is a family transaction where money is not changing hands, it's simply not a viable option. If they had $50,000 to use toward helping their kid find local housing, it'd be much simpler to just give it to them, to put it towards a down payment. But that does nothing toward building a community where families stay for generations, or where we live close together so that we can take care of our aging parents instead of putting them in some government-assisted senior care housing. Those are the kinds of things a family division exemption will help us with. I know from discussions in your workshop that some of you may have concerns about this process being abused by developers. I am very confident it will not. As a group, developers are frankly just not that patient. The waiting period on the front end of the process and the 5-year restriction on the back end of the process, along with other restrictions, reduce the utility of this code provision to almost zero for a developer. And that's by design. Division by family exemption is not a significant contributor to the number of new parcels created in either Bonner or Spokane counties. The same will be the case here. I envision this exemption will be used more often than testamentary provisions of the code. That's where you can create and grant individual parcels through your will. It's pretty hard to get excited about a process that requires you to die to pull it off. The family division exemption will be used far, far less than the 20-acre exempt division that we currently have. That process likely results in well over 1,000 new parcels created in Kootenai County every year. I know one company that this year created approximately 600 parcels by exempt division. We don't seem to have any concern for those divisions having no restrictions or controls on them. This process will be used far less frequently to create a very small fraction of the new lots we see every year, and it has a built-in review process to ensure compliance. But it will be life-changing for some families that can put it to work for them. So the benefits to the community from this exemption, in my opinion, far outweigh the minor fears and concerns for how it might be abused. And we would appreciate your favorable recommendation to the board. And I would stand for any questions you might have.
I would like to ask on 2C, ownership of the parcel to be divided, cannot have changed within the previous 3 years. Why did you choose 3? Why not more?
Because I think the purpose of the provision, again, is to prevent the flippers. Somebody who's going to come in and try and flip it. I think 3 years is long enough to prevent that. They generally are not that patient. And I think 3 years accomplishes that mission without, without excessive delay there. I mean, it could be 5, it could be 10, it could be 50 years. But, at some point it is, again, the purpose is to discourage somebody from buying it and trying to flip it. And I think 3 years is long enough to accomplish that mission.
Okay. And then the other question I have is number 5, the very end of your submission. Parcels created pursuant to the subsection that are not retained by the grantee shall not be eligible for building or development permits until a period of 5 years has elapsed from the date of recording of the division. So this is saying that once the family division is made, they cannot build for 5 years, or?
No, if it's not the original grantee. And so, we can certainly envision scenarios where things don't work out like we had planned. And so, no worries. You scared Commissioner James, though. So you certainly have situations where things, don't work out for that family for whatever reason. We can imagine a dozen different scenarios potentially. And so what this provision does is it says, if things work out, that's great. The parents give the child that 5-acre parcel. That child can go and get a building permit on it immediately. He's the original grantee, or she is the original grantee. They're eligible for building permits. But then if that child, for whatever reason, gets moved overseas or something like that because of a job or something like that, then they go and they sell it. Well, what happens then is that parcel then, upon its sale, would not be eligible for building permits. Assuming that that they haven't built a house on it, that's a much more meaningful restriction, of course. But that would prevent a subsequent owner from being able to build on it until that 5 years had lapsed.
What about, so let's say the child decides that for whatever reason, they are not going to be able to live there. They had thought they were and they are not. And there's another sibling that got another parcel of land. Would that would there be some sort of way that the sibling could sell to the other sibling? Would this come into effect because of that? Or?
I would expect that. That becomes a little bit of a interpretation or a code administration thing. But if it's moved over to another sibling who would otherwise have been qualified to do it, I think the department, could look at that and go, no, it's 6 of one, half dozen the other, and that would be fine. But if it's outside of that family situation, it is intended, again, this is intended to reduce the temptation or the ability to play games with this for the people who are just trying to flip it. We want this to work for families, and for the purposes that it's intended.
Thank you.
Rand, I have maybe more of a philosophical question than and I don't dispute your belief that developers are not going to play in this space, because number one, it's only 4 parcels, and number two, it could take 8 years or whatever. My concern with this is more about an exemption that has no real requirement that it stays. The reason it was granted does not require that the land with those exemptions stay for the use that is stated. You know, in the write-up you gave us, you talked about living in close proximity to family provides more frequent opportunities for little things that make life easier, better, and more enjoyable. They can include regular family dinners together and easier solutions for daycare. And I'm not going to read everything, but that's pretty much what you said.
Yes.
And I totally get it. And, you know, you have to, I have no belief that the applicant's desire for this is for the intended purpose as stated here. But what I don't see anywhere in here is a requirement, because this exemption, in my understanding, would mean that the road standards for minor subdivisions and other things, the $50,000 you talked about, would not be required. And I understand the cost impact, and I totally get our regulations add money to builders and developers who could probably afford it if you're a developer on. My concern is that you could have situations where the reason for this is the family to be together, and the family never gets together. Because, you know, and I could think of an example is that you gave me, you're my dad, and you gave me the land. I could build on it from day one. I could rent the property out for 3 years, okay? Then I could sell it to somebody who could live in that property with a house for 5 years. Now, I can't get a building permit, so if something happens to the house, they're in deep trouble on that. Why isn't this saying that, you know, just like every other exemption, we have exemptions for income tax, that if your income is below a certain level, you get a special dispensation for income tax. But if your income rises above that level, you lose it. If you get an ag exemption, it's based on certain requirements. Why doesn't, and I know your answer to me at the workshop didn't make a lot of sense, quite candidly, is why isn't there something that says, okay, we're going to do it for the intended purpose, but if after 3 years they sell that property to whoever, that person who is a purchaser would have to go and adhere to the minor subdivision regulations. And your other point, which was a valid point you brought out in our workshop, which I would propose we actually remedy, is when someone dies, inheritance laws are a lot different than gift laws. I could take my stock and divide it among my children, you know, without any monetary hit for them until they sell it later on. So there are reasons why subdivisions are in my inheritance type of thing. But I would propose that we would go and make that stay with a requirement that you have to adhere to whatever subdivision regulations are there. So my question, long-winded, is why isn't there something that says, you know what, I agree with you. We want to enforce, we want to do this. It's the right thing to do. However, if it's not used for whatever reason, the purchaser of the property would have to bring it up to standards, whatever the standards happen to be that day.
So my concern with that is that it sets a real potential trap for a future buyer. And
Right.
it might not, you know, the family that falls apart, for lack of a better word, that, you know, the family whose plans got blown up for whatever reason, you know, they may have moved on, and then you've got the next owner who thought he was buying something okay. And he may well not be able to solve it by the minor subdivision
Could be.
process.
Could be.
And so then what has he got? And the good folks in the planning department work very hard to protect against those situations. That's why you do you go through the subdivision process in the first place, is to make sure that, it's got X, Y, Z, meets the standards. And so once you have deemed something a legal buildable parcel, really that ship has sailed, and it's out there on the market. It gets sold, bought and sold, and so on. And the department has historically, and I think needs to, honor those kinds of things, because you end up penalizing the wrong person. You end up penalizing the unsuspecting buyer, if they can't do it. And also, you may enter into this today, where you could do the minor subdivision as a, escape route if you had to. But 2 years from now, what are the rules going to be? What are the highway district rules going to be? What are the health district's rules going to be? And they, while I can go get a building permit oftentimes relatively easily, I can't get through the subdivision process because those requirements are meaningfully different.
Yeah, I think, see, I guess and I don't want to belabor this too much, but, because I think the concept versus we're, as a planning commission, not everyone would probably agree with what I'm saying, but we're trying to, with a minor subdivision, to fix a problem with infrastructure, which is part of the comp plan, okay? And we're looking, and I don't know where that's going to be, but this thing here is contrary to the comprehensive plan when it comes to providing an adequate infrastructure. And to your point, which is valid, that if this was hopscotched around the county, it wouldn't necessarily be a big problem, 4 parcels here and 4 parcels someplace else. But what I worry about is 20 years from now, okay, and 30 years from now, as other people decide to give property, Leith decides to give property to his kids and all that, you're going to have more and more parcels potentially not in the family anymore, for a variety of good reasons, with inadequate infrastructure throughout the county. So what I was trying to think about this application seriously, I was trying to come up with a way of mitigating that potential impact by saying, you know what, families stay together, great. But if it's not families, then they should be treated like everybody else who is dividing their property. So my Lee's next door neighbor may have 4 kids also, but may not want to do this. So they'll have to do something different, or maybe they don't have 4 kids. So I just wanted to bring it up because I think that's my trouble with it, is if I'm trying to make it work, I'm trying to make it work, but only work for the exemption purposes as stated, not what could happen. And you're valid about the fact, who knows what the regulations will be 5 years from now. But the buyer, my friend, Commissioner Malloy, would always remind me that the buyer is responsible for deciding whether they want to buy a property or not buy a property, and they should be aware of whatever's going to happen when they buy the property. The county should not be into the big brother approach to that kind of stuff. So I would parrot that and say, I would let them worry about the buyer.
Well, and I'm a big proponent of that philosophy too. I'm much more inclined to ask people to be self-reliant and not ask for someone to be looking over their shoulder. That said, I have not come up with, I've given this a fair bit of thought. And it's not obvious to me how we would go about doing that, I don't see an obvious, simple, straightforward mechanism by which you do that doesn't potentially create I don't see a mechanism by which you could go back and say, hey, you've got to come back and plat this now, because the process for platting is a moving target and it's getting harder every day. And I fear if we say, well, that's the remedy, it may not be an available remedy 2.5 years from now when it's necessary for that guy. And, and how do we unwind that? How do we deal with that? And I don't have a solution for that, but I'm certainly sensitive to the problem, or the concern. But I guess I would go back and say, look, it's no different than, from an infrastructure standpoint, it's no different than 20-acre divisions. It's no different than testamentary provisions. Both of those, don't have those kind of considerations. You have to meet fire code standards for your access. You've got to still comply with the health district requirements for septic systems and IDWR requirements for your well and all those kinds of things. There are protections there.
Yeah,
And if we were going to do a lot of them, perhaps greater protections would be necessary. But again, I don't think it rises to even a significant number that occur.
okay. Yeah, the only reason I brought it up was that those things were available to everyone. Okay? This is an exemption. That by definition, to me, an exemption means you're being exempt for a specific reason.
Well,
Okay.
but the 20 acre things are an exemption. 20 acres is an exemption. The testamentary provisions are an exemption. This is no different. It's just a qualified exemption that
But everybody with 20 acres gets it.
anybody with 10 acres would potentially be eligible, because we've got a 5 acre minimum. So, so yes.
Add a little bit to that. I think one of the concerns are, if there were a process to remedy, or the subdivision process that were required in that event, there would be some challenges with divisions taken within the tribe reservation and within the ag zone. Being that this exemption would apply to those areas, it would be hard and actually prohibited by code to remedy one of these by the subdivision process in the agricultural zone. So there would be some challenges with that approach, but just for some food for thought. And also, I just wanted to make some clarification too, that I don't believe that this is limited to a number of parcels of 4. This is however many family members they have. So this isn't a maximum of 4. Right. Yeah.
Yes, that is correct. The county's initial draft on this from a couple of years ago may have had a limitation of 4. I believe Bonner County's requirements, that Bonner County may limit it to 4. This one, we did not feel that was necessary.
Okay.
In our
Thanks for the
draft.
clarification, Ben.
Then I have a couple more
Madam
questions.
Chair, just wanted to add to Ben's comments and, also Rand's follow-up. Another thing the original county proposal had was that it would have prohibited these family divisions in the ag zone and within the boundaries of the Coeur d'Alene Tribes Reservation. Both of those restrictions were removed from the proposal before you tonight.
My question is, how long has your client had his Post Falls property that he would like to gift to his family?
Since 1992.
So for quite some time.
Long time.
So that's why I asked about why the 3 years, because to me, you don't get a true feel for a community until you've been here a minimum of 20 years in my book. So with this number 3 here, I would think that, buying property and hoping that your kids or your grandparents or somebody like that would come in, I would think that you would want to actually know the area for a minimum of 10 years, to be honest with you. Because that would mean buy-in for yourself as well as the kids or grandkids would actually have a better feel for the community, and they might actually like the community and therefore buy in more to this family process. So that's why I ask, because I've been here since '88, and so it took me 20 years before, when I got here in '88, before I felt like the native Idahoans were accepting me as an Idahoan, so in that aspect. The other question I have for you is, how long has this code been in place in Spokane and Bonner counties? Because you said you kind of harvested the best from them.
So Bonner County has had their family exemption for quite a number of years. I don't know exactly what that is, but I believe they had it, man, when I was still working here. So I think they've had it 15, 20 years probably. I can't speak to Spokane County. I don't know when that came into existence there.
Because I would, with what you know about Bonner County, how has it worked for them, I guess is my question.
From my discussions with, I've talked to a planner that has worked up there for a long time about it, and he says hardly anybody uses it. You know, that he says, you know, it's not something that he sees on a regular basis. He doesn't believe that many parcels get created using their exemption up there, and I don't know why that is, but that was his observation.
Okay, thank you.
I have a few questions. So subdivision ordinances are in place and exist to protect society, right? Have to do something here?
Just your mic there.
Move it?
No, you're fine, just leave
I'm
that,
fine.
tuck into the other one.
Oh, and this one, okay.
Yes.
Got it. Sorry, I thought that one was taking the place of this one. Thank you. So I'm going to ask a couple of questions, and I really genuinely want to know your arguments in these areas, because they're important, I think, at least to me. The subdivision ordinances are in place to protect society, right? And the rules and regulations we have and the cost it takes to go through the process are meant to create some checks and balances to assure that parcels aren't improperly developed, you know, in a way that's harmful to the community or to neighbors and so forth. So when you have exemptions, which are exceptions to the rule in this area, it seems to me there should be compelling reasons. Here, I see an empathic reason. I mean, I'm a dad. I have kids. I'm really, this does hit me. I get it. But is it a compelling reason? And then the question, well, let me just ask that. Do you feel that is a compelling reason that we need to support transfer of property for families during the lifetime or give that opportunity to them? That's a compelling reason to have an exception to the ordinances.
I do. I think especially in Kootenai County here, it's become an even more compelling reason with the cost of housing and the difficulty of, you know, younger generations to be able to buy in here now. And so, yes, I think it is a compelling reason. You know, personally, my sister lives on my property. I fortunately am able to do that and am set up to be able to accommodate that. But being able to take care of a family member who's down on their luck or had some, you know, bad circumstances in life, you know, some people, family's not that important. For me, it's very important, and I think that is better for our society if we're taking care of our families, and one of the ways we do that is to have them close.
So maybe the tougher questions. Say we have disabled people, and the argument's made that it's compelling an empathic reason to give them exemptions. And so for disabled people, I have a daughter who's disabled, she's missing a leg. Why shouldn't she have exemptions when she goes and buys land and have certain benefits and protections that exempt her out of the subdivision ordinances because she's been down and out and had bad luck? And you could argue that's a compelling reason. And I'll give you a couple other examples. What about people who are in medical indigency? They have a bad medical situation happen, and they're running out of money, and they want to sell their land and increase the value of their land. Why wouldn't we give an exemption for them? And you see my concern. You start making exemptions and exceptions, then other discrete groups are going to want exemptions and exceptions potentially. And how do you respond to that concern?
I think part of the reason why I signed on to this with my client is that, I don't see people with disabilities that are struggling to work their way through the minor subdivision process, or, people who, maybe we could conjure up some other reason for an exemption. But I'll bet you I talk to a half a dozen or 10 people a year that are in this family situation that I talked about. And you'd be surprised at how many of the minor subdivisions, if your staff asked the question why, I think you'd be surprised at how many of them are motivated because of family, because they want to be able to accommodate a kid or something like that. And that there are a fair number where the process currently hurts them. And so, this is more than anything, it's because here's an area where if you poke around, you'll see that here is a need. And it's a defined need, and it's a need that we see today.
But
I can't speak to the other things because I don't see that.
Yeah, but I'm just pausing. There's other reasons why people could come forward and say we should get exemptions. But isn't the answer to the why, because it goes back to this protecting society and the community from improper development, that the why you have to go through the minor subdivision process or the subdivision process is to ensure those protections are in there so property is developed properly. And as Commissioner Levine pointed out, this is not only an impact for the first buyer or the receiver, the person who's gifted the property, but we're talking down the road, other people who buy and come in possession of the property. And that's the answer to the why, isn't it? That we want these breaks or these checks and balances in place to be sure the property is developed properly. I mean, isn't that the answer?
We do, but it kind of falls apart when we look at how many lots are we creating through these other exemptions? And, how does this fit in relative to that? And where we're creating 1,000 lots a year that we just wash our hands of because they're 20 acres, we don't look at water availability, we don't look at road access, you've got to comply with fire code access standards. But there's no no review process there whatsoever. You can do the same thing by putting it in your will, and passing it on to your heirs. And it just doesn't seem, when we have this potential benefit of keeping families together and helping out the people that are here and that have been here for some time. Again, we're so concerned about the abuse of it and so on, that we're stepping on the people that have been here a while, and their ability to take care of their own. And so again, I don't see it being used very often, and I think it is worth the sacrifice for these few lots to be able to help out these families.
Okay.
It's just, we may never agree on that, but that's just how I see it.
No, it's okay. It's genuine questions. I'm really, you have a lot of experience in this area, and it's helpful. And you have a few this year, but you do recognize you have an aggregating effect over time. You'll have more and more over time, as Commissioner Levine pointed out. I have two other areas I just wanted to ask you about. One is enforcement. We've already identified, I think, the other end of the table here, there are potential areas where, it really needs to be enforced. How do you envision enforcement of this statute?
I think, you know, it's gotta come, I think the procedure that's in here is you've gotta have, in order for it to be a legal buildable parcel, you've gotta come through, you do the notice of family division, that document gets recorded with the deed, so it runs in that, you know, it's in that, chain of title there. I'm perhaps more familiar than most with the department's record keeping. They have good record keeping. And so, yeah, you've got some enforcement things to look at. They gotta keep a list of who has received these in the past. You know, so they've gotta keep, nope, you've already received your exempt division. You're not entitled to another one. That's part of their review. But this is not complicated stuff. This is just fairly straightforward record keeping. And I have high confidence in the department's ability to manage that part of it. I think it's relatively straightforward, and I think it's far easier than most of the enforcement that the department is currently charged with.
The last area I wanted to ask you about is the discriminatory impact. Discrimination based upon filial status is already in a number of statutes, including I think the fair housing laws, and that could run afoul, it seems to me here. And what I mean by that is you're discriminating in favor of people who have children. And I understand whether they're adopted or natural, but they have children. But you have many people who can't have children or don't have children, and they will not be able to benefit from this law. And, you know, that troubles me that you have discrimination based upon family status. And how do you respond to that?
We all have parents, you know, and so we'd certainly benefit from the ability to make that dedication to our parents and not to our kids. You know, I don't have kids. I've got a brother and a sister, and so I would be able to take advantage of that. But maybe I'm an orphan and no brothers and sisters. You're right. I'm probably left out of this, but that's the same if I have 9 acres instead of 10 acres. I get left out of this. I'm not an attorney. I can't really address that. I don't know if that's something that the county needs to be concerned with. I would defer to Pat on that issue, of course. But I think it's available to most people, and just having kids is not, you know, or not having kids is not necessarily a disqualifier. So I guess that's my thoughts on that. Thank you. Thank you.
Actually, I want to, well, see, it feels like we're in deliberations already, so maybe it's not the time to say it. But you know, you wanted to get philosophical for a couple of minutes there. It's the first time I've seen that. But well, the whole thing, I mean, we've talked about it. I don't know who said what now, but you know, we're all concerned about what might happen. Something might change in 5 years. Something might change in 3 years or 20 years. Well, something did change back in 1973, my favorite date, when we wouldn't have to be talking about these exceptions, except that in 1973, somebody decided to create zoning in this area and start telling people how they should develop their land properly, whoever the judge of proper is. And so, of course, I shouldn't say of course, not everybody knows me, but I believe in a strong family. I think that any cause that promotes a strong family is a noble cause. And any ideas that deter or do the opposite, I'm opposed to. But back in the ULUC days, whenever that was, remember that was the people I heard from most were people who owned land, who had plans to divide it among their family. And so I know it's an issue, at least in the area where I live. And it galls me to hear someone come here to ask us what they can do with their land. And I've said that before, and so it's a repetitive thing, and maybe I'll say it again when we get to deliberations. But the idea that we can predict what's going to happen, or the reason we're exempting people is because we got this thing in the first place. One way to eliminate exemptions would be to eliminate the subdivision code thing we're talking about amending. So as soon as you start making laws and rules, you're going to start tweaking, and then you're put in a position of selecting favorites, whether it's your disabled child or whether it's someone with no kids. It goes on and on and on, and I'm not sure. I am sure there's no easy solution. But I'll say it all again when we get to deliberations.
I have recorded, Sean, you don't need to say it.
I want to hear it.
Are there any further questions?
Thank you.
Now we'll go to the public comment session.
Lynn, your mic, please.
Sorry. We'll go to the public comment section. Each member of the public may speak for up to 5 minutes. Members of the public should provide their name and address for the official record. And just to clarify, the public comment period is not a debate or discussion of issues. Commissioners may ask questions of commenters for clarification purposes, but will not engage in back and forth discussion. We'll start with Vince Hughes, who's in favor and wishes to speak.
Vince Hughes, 11791 West Prairie Avenue, Post Falls. And thank you for your time tonight. I guess I believe that the family is the building block of society. Societies that have had strong families have had a good society. And I think that we live here in Kootenai County where it's getting more and more difficult for younger people to be able to stay here. Anecdotally, I'll just tell you about two. There's a lady that worked at the Holiday Inn Express, and I run the ice rink in town, and so for the last 12 years we'd have had a relationship, not the full 12 years. She's been there about 6 years, or had been, and because we send people there to stay at their hotel when there's hockey tournaments going on or figure skating events or something like that. And she was a young gal when she first started working there, got married, started to have a family, a couple children, and she called me last January and said, Vince, I just want to let you know that my husband and I are moving to El Paso, Texas. We can't afford housing here, and the wages in El Paso are the same that they are here, so we can get ahead in El Paso. This past week, there was an excavator that I was talking to. He was doing some digging for me, and he said he's got a 30-year-old son, married a couple years ago, just started having children, building a family. They're moving to Tennessee. They can't stay here. My oldest son, I'm lucky that he was able to buy a house in 2016. He paid about $170,000 for it. He's a CPA. He was able to save. Being a CPA, they know how to save money and things like that. But now my younger children, that same house is over $500,000. I say, how will we ever get to the point where we can save enough for a down payment? And with interest rates going up, how much money do we need to qualify to build a starter house here in Kootenai County? So when I was talking to Rand about this stuff, I said, Rand, how do I, give 5 acres to one of my kids to build? He says, well, it's fairly difficult unless you die. And so, we had the different discussions and stuff, and he said there's been people in the past, or there's been discussions in the past about a family exemption. And so the more we discussed it, I said, well, I think it's for the good of our community, our county, for somebody to sponsor this and bring this up so that we can talk about affordable housing for young families. And so I said, Rand, let's start the process. So I think the people who benefit from this will be families. I don't think the developers will benefit from this. especially with interest rates going up, their carrying costs are just way too high. There's not enough profit to be made for buying, holding, going through a family member to split it, et cetera. So anyway, I thank you for your time.
Next, Michael Freed, in favor of wish to speak.
My name is Michael Freed. My address is 4795 West Woodside Avenue, Coeur d'Alene. And we have some property down in Worley also, 10 acres. And we want to split it. My wife wants to give 5 acres to her brother. And he's up here all the time visiting and working on it with us. We can't do it unless we have the family exemption. I don't think the subdivisions are gonna, or the investors are gonna have the ability to go through this process, and that's why I'm for it. Thank you.
And Gloria Freed in favor, and you say you don't wish to speak? Okay. I believe that that's all the comments that we have. Do I have a motion to close public comment?
Madam Chair, I do have a couple people on Zoom.
Oh, okay.
That may wish to speak. And so there looks to be 2 members of the public online. If you care to speak to this matter, go ahead and unmute yourself. Doesn't look like it.
Okay, do I have a motion to close public comment? Oh, okay.
She was in, actually. I let her in, but then left or was disconnected or something. Okay. But she was in earlier.
Can we talk amongst ourselves while we're waiting? Anybody
Well,
care?
are we closing public hearing?
That's what I have a question. I can't tell if I should do it during the public hearing or deliberations.
Deliberations, because public hearing, just listening to public, we could follow it.
Oh, yeah, okay.
Ran was staff report.
There she is.
Right.
Got it.
Yeah, it's sort of like blended. I may
Right.
have really blended it.
Yeah, right.
I'll make a motion to close the public hearing.
I do
Oh,
have
she's back
Deb.
on.
Yeah, Deb Mitchell, if you can hear me and you wish to speak, go ahead and unmute yourself. Deb, I don't know, again, I'm not sure if you're able to hear me, but if you would like to speak, now is your opportunity.
Okay,
Sorry.
I make a motion to close public hearing for ORA 23-2, exempt family division of land. Inc.
Second?
Seconded.
Commissioner Dean? Commissioner Glader?
Not here.
Oh, sorry. Commissioner James?
We're voting on
Voting.
closing the meeting.
Commissioner Malloy?
Aye.
Commissioner Zao?
Aye.
Commissioner Levine? Chair David?
Yeah, hi.
Okay, John.
Yeah, well, I'll start with a question, and that is, we've got this proposed amendment, and then we've got an exception already that's called testamentary trust or testamentary provision of an inter vivos trust. How do those two vary, other than that somebody has to be dead on the testamentary trust? Once the testamentary trust is established or utilized, whatever you want to call it, how does it differ in its, what do you want to call it, protocol or implementation?
All those are triggered when someone dies.
Right.
This would allow a division of land within a family if, without somebody having to die to do that.
No, I understand that. So we've got two cases. Somebody dies, and in the proposal, nobody dies.
Right.
So let's say that we have those two situations. How do they progress from the day somebody dies or from the day Mr. Hughes applies for the?
Well, in the latter situation, you would follow the.
Can I speak now?
We would need a motion to reopen the public hearing to allow the comment.
I so move. I move we reopen public comments.
Commissioner Dean? Yes. Commissioner James? Commissioner Malloy?
Yes.
Commissioner Zao? Yes. Commissioner Levine? Yes. Chair David?
Yes.
Okay, Ms. Mitchell, go ahead and speak to you. Deb Mitchell, are you available to speak?
Hello? I've got a lot of feedback.
Sounds fine here.
I'm sorry, I'm getting feedback here. I'm hearing two conversations. My comment on this is that this is a loophole around the zoning law, 20 acres. For example, several years ago, there was a gentleman who had 100 acres out off of Elder Road, and he wanted to subdivide it, and he was asking for a variance. The county refused to give him the variance, and he came back with the idea that, well, I can just give 5 acres to all of my 9 kids.
Ben, what was the name of the person?
And this screen name says Deb Mitchell.
So that's my basic comment as I see this 5-acre family allowance as being a loophole.
Is that the only person on Zoom? Okay,
Can you tell if that's the end of her comments?
I think it sounded like.
And we don't have anybody else on Zoom wishing to speak.
Okay. So, need a motion to reclose.
I'll make a motion to
Were
reclose.
you able to hear me?
Yes.
Yes.
Thank you.
Second?
Commissioner Dean?
Yes.
Commissioner James? Commissioner Malloy?
Aye.
Commissioner Zao?
Yes.
Commissioner Levine? Yes. Chair David?
Yes. Okay,
So what I'm getting at is, in the amendment here, the proposed amendment, we've got a list of things that have to happen to make it right. Is there a similar list for the Inter Vivos Trust? So,
It would just have to comply with the 3 requirements in that subsection, that being the parcel having legal access to a public road, meeting the minimum size for the zone, and is otherwise in conformance with all applicable provisions of the title. But no notice of division pursuant to a decedent's estate, for want of a better term, would be required in that case.
So if I understand it, then the proposed amendment is more restrictive on the family than the inter vivos trust?
Yes.
So that it doesn't have the 3-year requirement to hold the property, the 5-year after that?
No.
Okay.
And bear in mind, it would be, it would only, is in the context of an inter vivos trust, it would only apply to a testamentary provision of such a trust. In other words, one that is triggered through death. But no, it does not have all the requirements of that the proposal before you has.
So basically, it's like, when I pass away, I bequeath, give bequeath.
Yeah.
Give my kids.
It has to provide for the division. It can't just say, this land goes to my children X, Y, and Z. It has to say, this property, property A is to be subdivided amongst my children A, B, and C, or some sort of language evidencing an intent to subdivide the property. That's the other requirement for that, but it is pretty lenient, and I think more lenient than what we see proposed today.
Okay.
Exactly, which is my point, I guess.
Hey, Pat, or Ben, because I was mistaken about the limitation of the number of parcels, and I was always thinking about minor subdivision. It appears that if I had 40 acres and I had 10 people that fit within, or not 10, 8 people that fit within that definition, I could give each one of those 5 acres.
Under this proposal,
Under
that
the
is
proposal.
correct.
And then.
And I would note Bonner County has a limitation of 4 on theirs.
Okay.
Spokane County does not.
Okay, so then, 8 years from now, if a developer did buy all 8 parcels, I'm not saying they would, and I'm not.
Right.
They would be able to develop that without using a major subdivision?
Yes, they would be considered lawfully created parcels eligible for development permits at that time, because the 5-year waiting period would have passed.
So larger numbers would potentially incentivize a developer, could incentivize, okay. I didn't know that, okay, thanks.
Yeah, once the 5-year period passes, if this were, to become part of our land use code, once the 5-year waiting period passed, then the parcels are free to be developed as, to the greatest extent allowed in our codes. And they
Just
would
an
be
individual
considered
parcel.
lawfully created parcels.
Yeah, just an individual parcel, right? I mean,
Yes.
it just would be buying a bunch of separate parcels and then you develop them. Is that the situation, Pat?
Can you say that again?
Well, so like the example I gave, you have 8 parcels.
Uh-huh.
If a developer wanted to develop 3 of them, they could buy 3 of them, they develop them independently. Each one
Yes,
is a parcel.
yes.
Want all 8, they could do it with all 8, right?
Yeah, once the 5-year period is passed.
Right, okay.
Before the 5-year period ends, it would just be the grantee. And I might suggest that there be a friendly amendment to allow, another family member who's eligible to receive the parcel. In other words, somebody who is a member of the same family and hasn't already received one,
Right.
to substitute for the grantee. I think that would be a reasonable amendment.
See, I'm hearing 2 different things and I can't get it in my head. I hear the family need and the cost and all that. I get all that, and I'm not opposed to that concept. But I also hear that we're making it easier for the family member to sell the property in 3 years versus 5.
Actually, it would be, once the transfer occurred, the 5-year waiting period would kick in.
But that-
It's
that-
just,
yeah,
the
but that's
property
me to
has
sell
to,
the
have-
property.
the property has to have been
Right.
owned for at least 3
Right.
years.
So what I'm trying to reconcile is, I kind of understand what Rand said. He knows more about it than I do, about the difficulty of potentially making it almost impossible to do road standards 5 years from now or 8 years from now, then, because of things built around it. It would be very difficult to do that maybe. But part of me is saying, if it's a family, to keep family together, then why are we not making it 20 years you got to keep the land? If it's to keep family.
That's a decision this commission
Yeah.
can make.
If you want to keep
Um,
family together,
the five-
that encourages family
The
to stay
5-year,
together.
the 5-year period, though, is one that is in both the Spokane and Bonner County.
Right. That's after I
versions.
sell it.
Yeah,
Yeah,
After
yeah,
you divide
yeah.
amongst your kids.
Yeah, I divide it among my kids. They have to keep it for 3 years.
5.
5.
You have, to. You, see, that's my point. My point is,
I'm confused now.
no, my point is, so dad goes and buys this piece of land, and he only has to have it for 3 years.
Got it, okay.
Okay.
So I have to
That's-
keep it
And
for-
that's what my point was. My point is, you really need to, if you want to keep family together in
Okay.
order to know a community, you got to be here more than 3 years. You know,
Yeah.
that's my opinion.
So then the child or the brother or whatever, once they have it, they can't sell it for 5 years. after.
Well, I mean, the.
After
code
the 3
doesn't
years.
Yeah, the code doesn't prevent somebody from selling those lots, but only that they're ineligible for development permits within a 5-year period.
It serves to deter a future sale, but it doesn't prohibit it,
So-
like Ben just said.
Just so because I'm really having trouble tonight. Rand owns the property for 3 years. He divides it and gives me one, because I'm his brother.
Lucky.
Yeah, okay. I could sell it the next day,
Yeah,
but nobody could develop it for 5 years.
correct.
Okay,
That's why it says it's intended to deter that kind of a sale,
Yeah.
but it certainly does not prevent it. The scenario you outlined could happen.
so really, there's nothing that requires the family member to actually keep it. And they can make profit off it right away. 3 years. And,
5 years.
yeah,
You just
3
gave me
years.
an idea.
I could sell it on 3 years in 1 day, right?
5 years and 1 day.
No?
Oh, if
Yeah,
you're
I'm
the
selling it.
grantor, yeah, then 3
Yeah,
years.
I
and
could
1
sell it to Madeline. Rand stays there for 3 years. He
Yeah,
gives it to me.
yeah,
The next day I sell it to Madeline. Madeline can't do anything for it for 5 years.
correct. Yes,
But I could make money on it 3 years in 1 day.
that is, yeah.
I'm not
that
saying I
is-
would, but I'm just saying.
Right, that
Okay.
is a scenario that is possible under this proposal.
So I have a question, Pat. You got me thinking here, which is a scary thought, but, so I have 4 kids, all right? I've got about 90 acres, okay? I've got a bunch of 20-acre parcels. So right now, this passes, could I then convey 5 acres? I could avoid the minor subdivision ordinance and convey 5 acres to each of my kids who are out backpacking across Europe and do whatever they do at that age. And by the time they're really ready to make some money, 5 years from now, they need money to buy their house in some other location, they could turn around and sell it
Yes.
for development.
yes.
So why wouldn't every parent who has children want to then subdivide right away after the child's born? I mean, conceivably, they could give it to them, at the date of birth. And when the kid's 5 years old, they could be resold.
Theoretically, I
Oh.
mean, yeah, that is also possible.
So that would be a vehicle. I
There's
mean,
no,
to me,
there-
that's a
yeah,
good
there's
investment
no
vehicle.
age limitation on this as proposed.
I see that as a really, when I think about it, it's a really good investment vehicle for,
It's not our job.
You're gonna start having more kids?
yeah. What's that?
So you're gonna start having more kids?
Well, I might start adopting, put that way, if my wife would let me. Yeah, no, I see that as
Have to
one
be
way
5 acres. Can we do more?
to maximize your land value.
So So the minimum lot size would be whatever the zone?
It would be 5 acres regardless of the zone.
Oh, okay.
But it could be more.
It could be larger, yeah.
Yeah, okay.
And then,
That I wasn't clear on.
This would apply down, and with the way it's written down in the controversial area now with in the tribal
As
boundaries.
proposed, yes, because that was, and that's one of the differences from my original proposal.
So let me ask this. As things stand right now, if somebody's going to do a minor subdivision, as I understand it, the county notifies the tribe. The tribe has now stepped in and said, we're not going to allow those, and we have this other issue that's percolating through. Would the county notify the tribe that a family is subdividing it into 5-acre parcels? Are we going to end up in the same kind of conflict or no?
No, that's a David Callahan question, and they wouldn't be required to, let's put it that way.
I think you said they wouldn't be.
The prospective grantor would have to have evidence that they've discussed the division with the highway district and with Panhandle Health, but that's it. There's no other. There would be no other agencies that we would be required to send it to.
Well, I had a question about that.
Whether we chose to send one within the reservation to the tribe would be a staff call, ultimately a director's call.
Is it still just discussed? Does the person have to comply with the highway district and the Panhandle Health
yeah.
requirements?
Yeah, because, they would.
Okay.
Even though there's no plat to sign off on, they'd still have to, at least show evidence that they discussed the matter with both of those entities.
Well, my question there is, though, discussed is different than complying.
It does say discuss as opposed to comply.
Because that to me seemed like a problematic term in this, because discussing doesn't really do much. It's really complying that.
No, and I understand that. They would still be required to get, permit, for any required septic permits from Panhandle Health and any required approach permits from the highway district. But you're correct. It doesn't require compliance with even those two districts from our perspective, from an approval perspective by the county.
So in our effort to make sure we consider every devious plot that could possibly be conceived, we're discriminating against good, honest mom and pop who want to keep their kids around the house.
John, I mean, what we're discussing is they don't have to keep the kids around the house. That's the problem. See, this is the problem I have, is they don't have to. If they had to, then that's a whole different ballgame. To say you want to, and maybe your kids don't even want to be near you, that could possibly be not your children. They like you, but generally, see, that's where my head is. I'm having trouble with the fact that we're giving an ability for a noble purpose that doesn't necessarily have to be done. If everybody wants to have their family around them, so make it that they have to stay around them. But you can't do that because you don't know what's going to happen. What's going to happen is a child may get his job moves. I mean, you can't forecast the future.
Exactly.
So the question becomes is, do you provide this, not because we think they're going to be used for devious things, but are you providing an exemption for a purpose that may be good, but doesn't require that it be used for that purpose? And that's where I'm having trouble. And I tried to come up with a way of figuring it out, that, if they didn't use it, fine, but then let the next person pay more money to get the thing to be brought up to the minor subdivision, or in the case of major subdivision regulations, but it doesn't require them to do anything. So for no bad reason, a family member could give his gifts to their eligible people in here And in in 10 years from now, for no bad reason, because of circumstances of jobs, of illness, of a bazillion other things, all of those parcels could be owned by non-family members without having the same infrastructure and other things. Now, you could debate, and you do, John, I respect that we shouldn't have any rules. I get it. I'd rather have no rules than to have rules that are there for family members that don't have to actually use it for that. That's my trouble. And that's what I'm trying to come up with a solution to try to have both. And I can't figure it out. And Rand's point was spot on some of the solutions I had, or why it probably wouldn't work, type of thing. So that's the real question there. And again, we're only an advisory board, so really the big day is to be coming down the road. I also have a concern about, now understanding it better, that there's no limitations on the number of parcels. So you could have 8 or 9 parcels, of which 3 or 4 turn over. And then the tribe one is a whole nother issue, not a concern, but an issue. And then agriculture, which was originally in our stuff. So
Let me ask a follow-up question to that. It just occurred to me, again, back to my example, could I give 20 acres to each of my kids now? And then in 5 years, well, let's say they have children, which they probably will. Could they turn around and then subdivide those into 5 acres and give those away to my grandkids?
No, because the family division can only occur once on any given parcel of land.
Okay.
But, I mean,
So
would
the next generation can't do that.
would there be a different exemption that applies?
Yeah, I'm thinking
the
it
free
would.
split or 20-acre exemption?
I mean, well,
and
yeah.
the subsequent
that's
family
a-
division?
That's a good point. If they're 20 acres or larger, you could do just do a straight large lot division, and then each of your kids, convey each one to your kids, and then each of them could invoke the family division
I'm
exemption.
getting good legal advice.
Right.
So I should give them 20 acres each, and then each one of them subdivide for the grandkids into 5 acres.
They could do that if this proposal is adopted.
No, but I could.
Because the large lot division provision is already part of the code, so.
Right, but I could give them each 20 under that, and then
Yes.
they turn around and can use this to give 5 acre parcels away
Yeah.
to the grandkids.
Yeah,
So I could skin that cat, okay.
yes.
And then they could sell them
After, yeah.
I'm not sure.
and make pretty good profit, yeah. I agree, family is the building block of society, I agree with that, totally agree with that. And it's more difficult for younger kids to afford, and that's a worry I have, and I agree with that. I'm running into some of the same trouble that Dave's running into. The unintended consequences of this thing, it doesn't really achieve what you want to achieve. Is the vehicle to achieve what you want to achieve? I also agree in expanding individual freedoms and liberties as much as possible. The problem is, at some point, they start to infringe upon others, and that's why we have rules. And we can debate all day long where that line is, how much we should have rules or not have rules. I think we all agree we should not abolish all rules, except for when it comes to what I want to do, by the way. But you don't abolish all of them, but you need rules, so where is that line? We can debate that all day long, and I respect that debate. And I also respect the concept, well, maybe we got to revisit this whole subdivision idea, the whole zoning concept. Maybe we got someone with a higher pay grade than me should argue that and debate it and revisit it. I don't know. But I'm worried that this, one, could have unintended consequences that we can't even envision right here. Two, that's not achieving what goal we achieved. Now that I know how I can use it as an investment vehicle for my kids, I really do think that's a valuable thing. I could really make money with that. And I don't know that's fair to my neighbors and everybody around. I'm worried about the discriminatory nature. The subdivision ordinance, like any ordinance, it's kind of like a tire. When you start giving exceptions, you're taking a little bit of air out of the tire. And it doesn't really, you don't notice it much driving down the road initially. But there comes a time where you take so much air out of that tire, it doesn't roll anymore. And you got a real problem. And I'm more in favor, if you're gonna revisit, if you have a subdivision ordinance and you think there's problems with it, then visit that and debate that and fix it, rather than creating a bunch of exemptions anyway, that's my view.
Any other discussion? Does anyone want to bring forward a motion?
Well, clearly I would move, and I will move then, that we accept this amendment as presented with our recommendation that the Board of County Commissioners accept the amendment to, what are we talking about? ORA
230002.
0002.
Did you want to include what Pat was talking about, where you could transfer, if a sibling transfers their,
That a transfer to another eligible family member would be allowed within the 5-year period.
I would include that.
Okay.
and you want to keep it at the 3-year?
Yeah, that's what I'm saying is.
3 and then 5.
Yeah.
That's what it sounds like to me. Sir,
Well, the opposite. I mean, there's variations to the theme. Vote to approve it with these exceptions. Well, you know, I'll just make a motion so we can get this to the county commissioners. I make a motion to deny ORA 23-0002 exempt family division of land for the reasons I've stated.
that would be to recommend denial.
We recommend denial. Thank you, Pat. So that's my motion.
Do I have a second?
I'll second that motion.
Commissioner Dean?
Yes.
Commissioner James?
Yes.
Commissioner Malloy?
No.
Commissioner Sale?
Yes.
Commissioner Levine?
Yes.
Chair David?
Yes.
I hate this whole thing.
I do too.
I really hate it.
We are adjourned at 7:23.